Good morning to those who've joined us. We're just waiting for some more folks to join before we get started. Well, I think it's 10:01, so I think we'll go ahead and get started. Good morning, everyone, and welcome to the third training in the Disability Law Center's training series this summer. Over the course of the summer, DLC is presenting a training series titled Your Rights Throughout the Mental Health System. Today, we're talking about your rights regarding medication and treatment at an inpatient facility. My name is Ginger Gates. I'm a staff attorney at the Disability Law Center. I am joined by my colleague, attorney Walter Nunes. I'll have him introduce himself in just a minute. I am a white woman in my late 20s wearing black framed glasses. I have blonde hair and I'm wearing a light blue dress shirt. My background is mostly light colored and you can see my wardrobe and closet door in the background. My pronouns are she and her. And I'd just like to note before we get started that this session is being recorded and it will be posted to the DLC website. You all should have access to the slides as they were emailed to you prior to the start of today's session. So I'll just have Walter go ahead and introduce himself.
Thank you, Ginger. My name is Walter Nunes. I'm a senior staff attorney at the Disability Law Center. As you can see, I got a bunch of books behind me here. I'm a middle-aged white male with rather longish brown hair. My pronouns that I identify with are he and him. I've been working at DLC since 2003, primarily on issues involving folks with lived experience. I think this series has been really helpful to me as well as the folks who view it. So we look forward to a wonderful presentation by Ginger. And I'll drop in later when asked. Thanks. Bye.
Thanks, Walter. I will just note that there are ASL interpreters available to be pinned if you need them. And you can also drop questions in the question and answer box or in the chat box throughout the presentation. And we will do our best to answer those questions. I think we can go ahead and get started and move to the next slide, please. Thanks. So as I noted, today we're talking about your rights regarding medication and treatment at an inpatient facility. There is a lot to this topic, and I just want to give a brief overview of what we're going to talk about today. First of all, you have the right to informed consent and to consent to treatment before it is administered. And inherent in that is also the right to refuse treatment. Informed consent is really foundational to health law and to understanding your rights related to medication and treatment, so we're going to spend some time on that. You also have the right to treatment that is suited to your needs. You have the right to participate in the development and implementation of your treatment plan. You have the right to view and amend your medical record with some caveats, of course. You have the right to interpreter services, and you have the right to reasonable accommodations under the Americans with Disabilities Act, including to American Sign Language interpretation. I just want to be clear that this is not an exhaustive list of the rights that you have, but this is where we're going to focus today. So we can go ahead and move to the next slide. Who do these rights apply to? So under the Department of Mental Health regulations, all facilities that are licensed by, contracted for, or operated by the Department of Mental Health must follow those regulations. And many of the rights that we're discussing today are in the regulations, but I think it's also important to keep in mind that some of the foundational concepts in health law, like the concept of informed consent, for example, they're based in case law. So they're based on cases that went through the court system and what a judge decided. So we'll spend some time talking about that. Additionally, some of the workarounds to informed consent, like a Rogers order and an 8B order, those are either codified in state statute or like the Rogers order, those are based in case law as well. The bottom line is that the facilities are responsible for ensuring laws and regulations are being followed, and the human rights officer at each facility should be available to take complaints regarding these rights and other rights. We do have another training in a few weeks regarding the complaint process, so we will be talking about that at a later time. All right, I think we can move to the next slide, please. Where can you find laws about rights regarding medication and treatment? As I just mentioned, informed consent in Massachusetts is based in case law, although it is mentioned in state statute and in the DMH regulations. The paramount case in Massachusetts is called Harnish versus Children's Hospital. This is related to informed consent. Essentially what happened in that case, a person underwent an operation to remove a tumor in her neck, and during that procedure, a nerve was severed, which resulted in permanent and almost total loss of her tongue function. And that person then brought a lawsuit against the surgeon and the hospital, claiming that they were negligent in failing to inform her before she had the surgery that her tongue function was at risk. The court found that physicians owe patients a duty to disclose in a reasonable manner all significant medical information that that physician possesses that is material to an intelligent decision by the patient whether to undergo a proposed procedure or treatment. So essentially, informed consent, when you break it down, it's exactly how it sounds. It's informed. You have to have the information to make and to consent to specific treatments. The DMH regulations also detail some important information about informed consent at 104 CMR 27.10. We'll talk about that a little bit. The DMH regulations 104 CMR 27.12, prevention of restraint and seclusion. Those regulations detail when and how medication can be given against a person's consent as an emergency restraint when someone is at imminent risk of hurting themselves or others. We will have another training on that topic specifically. Also, Massachusetts General Law, Chapter 123, Section 8B. This details court-ordered antipsychotic medications through the district court. And then you've also got Rogers versus Commissioner, which concerns Rogers orders, which is another form of medication without your consent. And then you've got the DMH regulations 104 CMR 27.13, which is again outlining the right to treatment suited to your specific needs. And then you've got regulations about access to your records and record privacy. And then, of course, the Americans with Disabilities Act, Titles 2 and 3, which requires that government-operated entities and places of public accommodations provide reasonable accommodations to people with disabilities. So with that, we will move to the next slide and start our discussion about informed consent. So again, informed consent is really foundational to your rights regarding medication and treatment. The DMH regulations define informed consent as the knowing consent voluntarily given by the patient or his or her legally authorized representative who can understand and weigh the risks and benefits of the particular treatment, including medication being proposed. So what does that actually mean? In a nutshell, if you have capacity and you are competent to do so, you must be informed about the treatment you will receive and then voluntarily consent to that treatment. So the key concept here is competence and capacity. You must be capable of making those decisions for yourself and to act for yourself as to matters concerning personal health, safety, and general welfare. You are presumed competent even if you are involuntarily committed to an inpatient facility. We can talk a little bit more about the informed part of informed consent. So the idea is that clinicians have to give you the information that you need to make a decision for yourself. And they must explain the procedure or treatment in terms that you can understand. So, at minimum, they should be explaining the nature and extent of your illness, what medication or treatment that the doctor wants to prescribe and why, the benefits that the doctor believes will result from the medication or treatment, the nature and probability of risks associated with that medication or treatment generally, but also with specific regard to your health. So any special risk that the medication or treatment might pose to you. So for example, if you have hypertension, going on some medications might raise your blood pressure even more. So the doctor should advise you of the risk that is specific to you in taking that medication, particularly to your blood pressure. The doctor should also inform you about alternative treatments, which includes foregoing treatment altogether, and what that prognosis would be, what the risks are of not seeking treatment at all. And when it comes to antipsychotic medications, you have to give specific informed consent to that treatment. So antipsychotic medication, along with some other treatments such as surgery, for example, are considered extraordinary treatment. And those types of treatments you have to specifically give your informed consent to those types of treatments. And that must be noted in your medical record as well, that you gave that specific informed consent to be treated with antipsychotic medications. Walter, I don't know if you had anything that you would like to add. I would just
do briefly, if
Sure.
if it's okay. I thought that was outstanding, and a couple of things that I wanted to talk about. You talked about the capacity to give consent, and about specific informed consent. Sometimes specific informed consent is affected by when. For example, many times a person might be brought to an emergency department where they might spend many hours waiting for an inpatient bed to become available. And then they're transported at 11 o'clock or 1 o'clock in the morning to an inpatient facility. And they meet with the doctor when they're very, very tired. And a lot of times they call these black box warnings. On an admission sheet, a doctor is required to give specific information regarding extraordinary medical care, and they call that a black box warning. And far too often, I've read those sorts of reports where the person, even in the doctor's description of the individual, they talk about the person being tired or sleepy or not really being able to participate in the conversation. Yet that doctor will check off that they provided the client with the black box warning. So sometimes capacity is as simple as just being well rested, that you can fully understand, particularly with respect to extraordinary care or invasive care. So I wanted to raise that. And also, just as sort of a little flag, restraint is never treatment. And even though we're talking about treatment and consent to treatment, a very effective byword that I've often heard said is that restraint is the failure of treatment. So whenever medication is used in the context of treatment, in the context of a restraint, it's not treatment at all. It is the failure of the facility to treat, and they use an extraordinary measure to keep a person and others safe. So I just wanted to state that. Thanks so much.
Thanks, Walter. I think those are really good points. And I would just add that inherent to the right to informed consent and to give your consent to treatment is also the right to refuse treatment. So if you have capacity, you can refuse any medication or treatment that a doctor or hospital is offering to you. I think we can move to the next slide, please. Thanks. So what are the caveats to this? When can you be treated with antipsychotic medication against your wishes? There are 4 circumstances really under which you can be treated without your consent. And I will also note, as Walter noted, that emergency chemical restraint is not treatment. But that is one of the circumstances under which you can be given antipsychotic medication without your consent. There's also rare circumstances to prevent an immediate, substantial, and irreversible deterioration of your mental illness. That one is used very rarely. I think between the two of us, Walter, I've really only seen it once. You can also be treated pursuant to a district court order under Section 8B. And then you can also be treated pursuant to a probate court order, which is otherwise known as a Rogers order. So we can talk about the emergency chemical restraint, and I don't want to spend too much time on this just because we'll have a whole training devoted to this topic at the end of July. I just want to make sure we get through everything. But a chemical restraint occurs when a patient is given a medication or a combination of medications to control their behavior or restrict their freedom of movement. And chemical restraints can only occur on an emergency basis. A doctor can only chemically restrain you if there is an occurrence of or a serious threat of extreme violence toward others, personal injury, or attempted suicide. And just like some of those other rights that we've talked about with relation to the 6 fundamental rights, less restrictive alternatives must have failed, or those alternatives would not be appropriate or would not be effective under these circumstances. So essentially what that means is that the clinicians are really supposed to be trying to de-escalate the situation before they move to chemically restrain you. Moreover, facilities must develop an individualized crisis prevention plan with each patient, which should be followed during a chemical restraint. And those individualized crisis prevention plans, they're supposed to be developed with your participation. And they might call for a physical restraint prior to a chemical restraint. If you have concerns about medications, it's supposed to be an individualized crisis plan tailored to your needs. Walter, I don't know if you wanted to add anything about chemical restraints before we move on to that second exception, which is the strange one.
No, I think you're right. I think, I think it was great that you picked up on the idea that a restraint is not treatment, but it does use medication. And I think that a little bit later, I'd like to talk about how consent is actually grounded in tort law. And I think there's a couple of places where we could chat about that. Thanks.
Sure. We can go ahead and move to the next slide, please. So the second circumstance under which you can be treated with antipsychotic medication against your personal consent is very rarely used, like I said. Essentially, the right to refuse medication can be overridden prior to an adjudication of incompetence to prevent immediate, substantial, irreversible deterioration of the person's mental health. So in order to invoke this exception, the patient must be believed to lack capacity to give informed consent. If the patient is a minor and their parent is making treatment decisions, then this exception cannot apply. It doesn't work. It also doesn't apply to adults who have a healthcare agent who is making treatment decisions. And again, it's only used in rare circumstances to prevent immediate, substantial, and irreversible deterioration of a patient's mental illness. And if after that, first treatment to prevent deterioration, the treatment team thinks that this treatment should be continued over the patient's objection, then they have to go to court and get a judge to rule that the patient lacks capacity, and then for the judge to approve a treatment plan. So this can only really happen once. And again, between the two of us, Walter and I have really only seen one instance of this being used. So it is really rare. We can go ahead to the next slide.
If I could.
Sure, of course.
think there's a distinction between the emergency application of medication, which is an extremely rare scenario, which I've only seen once. But I can say that while I don't agree with the way some hospitals interpret these laws, many hospitals believe if they petition the court for a court order to treat someone, while that is pending, they have the latitude to continue to treat even before the order has taken place. I do not believe this question has been adjudicated or settled. I personally think it doesn't make sense. It's separate and apart from emergency treatment. It's like a person needs treatment and they really feel they have to intervene. They can, in certain circumstances, intervene once, which is not emergency treatment. It is straight up treatment, but the requirement is that they then seek a court order. And practices is they often will continue to treat with that medication even before the order has been granted. This is a question which is troubling, and again, I don't believe it's been adjudicated, and we can research this further if folks want us to. And I just wanted to point that out. Sorry for interrupting. Thanks.
No worries. Thanks, Walter. Yeah, so the third way that an individual could be treated without their consent is under what's called an 8B court order. And we did discuss this in the first training that we did, so I don't want to spend too much time. But the basics of the 8B require that the person be subject to a petition for commitment, or that they have already been ordered committed under section 7, 8, 15, 16, or 18. Sections 7 and 8 relate to civil commitment, and then 15, 16, and 18 relate to commitment during adjudication of a criminal defendant's competency to stand trial. So the first step is that they be subject to a petition for commitment, or that they have already been ordered committed. And the court must rule on that petition for commitment prior to ruling on the 8B petition. And the 8B petition, essentially a representative from the facility, petitions to the district court to first find that the person is incapable of making informed decisions about proposed medical treatment, so they lack the capacity for informed consent. And then they're also asking the court to authorize treatment with antipsychotic medications through the substituted judgment standard, which the substituted judgment standard, again, was discussed in a previous training, but it's not a best interest standard. It's different than asking the question, what's going to be in the best interest of this patient? The goal of the substituted judgment standard is really to determine with as much accuracy as possible the desires and the needs of the individual involved. So really what the court is asking, what would the incompetent person decide if they were competent? And there are many factors that go into making that decision, into making that adjudication. For example, the patient's expressed preferences regarding treatment. If those preferences were expressed while the person was competent, that would probably hold a lot of weight in adjudicating substituted judgment. Also, a factor is the strength of the incompetent person's religious convictions, to the extent that it may contribute to their refusal of treatment. Another factor, the probability of adverse side effects, the prognosis without treatment, the prognosis with treatment, if it's likely to improve their condition, and then other factors that seem relevant to the court. So again, the first adjudication that has to happen is that this person is incompetent to make these decisions, and then the court will ask, what would this person do if they were competent? And then the court will authorize treatment with antipsychotic medications, and they can also authorize other medical treatment that may be necessary for the treatment of mental illness. So if you are the subject of an 8B order, you have some rights. First, you have the right to be informed that such a petition is being filed on your behalf. You and your nearest relative or guardian will be notified of the petition and the hearing date, and that hearing should happen within 14 days of that filing of the petition. You also have the right to be represented. And also it's important to note that authorization for treatment expires at the same time the order of commitment expires. So once your commitment order is up, so is the 8B. And you can also petition the court at any time for a modification of the order. Walter, is there anything you want to add about this topic?
Yeah, we have a couple of questions, but I think you're completely right. You know, the 8B can only occur after a person has been committed. So if a person defeats a commitment petition, they can't move forward with the 8B. And it does expire. If it is ordered, it expires when the commitment expires, which is separate from the Rogers order. And I'll leave Ginger to talk about that. But I do have a couple of questions which I think are relevant and we should address now.
Sure.
We have a question. When would presumed competence be questioned? I think that's a real good question.
That is a good question. Walter, if you have any thoughts on that, I welcome them.
Well, I think that a person is always presumed competent.
Right.
If you're not under an order, you're competent as a matter of law. I think it goes to the issue of like, when do you seek to apply for guardianship?
Right.
You know, it's like if a person's competence is such that you just really don't think that that the doctor thinks that this is a real detriment to treatment. Well, that's just like any person exercising their right to medication. The doctor has the right, if they're not under a commitment order, to seek a Rogers order, or any other issue where the facility disagrees with the decision of a client. They can, you know, they can always petition the court for guardianship or a Rogers guardianship. If the client is under a 7 and 8, I believe they could still apply for an 8B as long as the 7 and 8 is still in place. So competency is sort of like, that's the baseline.
Right.
Everyone is presumed competent. When the doctor, who would have to submit an affidavit, can submit in writing to the court's satisfaction the reason why he or she does not believe the person is competent any longer. And then that there is a, depending on the petition, there is a limited right to counsel, depending on what it is. If it's the Rogers order, there's an absolute right to counsel. If it's an 8B, there's an absolute right to counsel. If it's general guardianship, there's a right to counsel, with the caveat that the person has to ask the court to appoint an attorney, which is a little odd. They don't get it absolutely. They have to ask for it. I hope that's helpful. And we have another couple of questions, I think. One came in while I was chatting away. This question is, my question would be, in the amount of time a facility has to develop an individual plan, and then part of that is, does the plan have to include the parents or next of kin who have remained involved but not our guardians? Is there such a thing as a safety plan for institutions? Does the right to treat include private schools as institutions? That's a mouthful. So perhaps maybe one at a time, and I'll just restate the first one. With the how much time does a facility have to develop an individual plan for the client?
Upon your admission, this is something that should be begun upon admission. Of course, treatment plans are subject to change, and everyone's mental health is slightly different, so it can take some time to find what works for you. But the process of implementing and creating a treatment plan should really begin upon your admission to an institution.
Sure.
Does the plan have to include parents or next of kin who have remained involved but are not guardians? So there's no requirement that those parents or next of kin be involved in the treatment plan. However, if there's a concern here about your privacy and the hospital or institution's compliance with privacy laws. So in order for parents or next of kin to be involved, you probably have to sign some form of waiver allowing them to access that information about your mental health. You certainly can have your legally authorized representative, which may be a guardian or even a healthcare proxy, involved in that treatment plan discussion. And you can also, if you have an attorney, they can also be involved in that discussion as well, with your consent. Did you have anything you wanted to add to that, Walter?
No, there are two more pieces to this individual's question.
Yes. Is there
No, that was great.
Is there such a thing as a safety plan for institutions? So two things. First, and for an individual, yes, I would call that the individualized crisis plan, which is intended to kind of have a plan in place for each individual patient at an institution who may go into crisis. If I'm, on a floor and I begin to have a mental health crisis, there should be a plan in place for what's going to work for me. For me personally, maybe I don't respond well to physical restraint, and so I would prefer to be chemically restrained if it gets to that point. Of course, they have to try de-escalation techniques first. With regard to a safety plan for the entire institution, there are certainly regulations that require there be those plans in place, for, a flood or a fire, et cetera. But I think that's probably what the question is getting at, is that individualized crisis plan. Does the right to treat include private schools as institutions? I'm not entirely sure exactly what this question is getting at. There is, if you're under the age of, I think, 20, or maybe it's 18 actually, there is a right to education if you are a DMH client. There may be private schools that are, residential schools or schools that are geared toward folks and students who have mental health challenges. Residential schools certainly would be considered institutions. And those schools, there are separate, I think there are separate regulations for those types of schools where they must have similar crisis plans in place for each individual student. Walter, I don't know if you wanted to add.
Yeah, I think this is really important. There is no such thing as a right to treat. No facility has the right to treat you. This discussion is about consent, which is your right as the individual to agree or to refuse treatment. I think a better way to say this is the individual has a right to appropriate treatment,
Right.
which could be anything. It could be, somebody skins their knees and you put a bandage on it. So the right that the client has, that the patient has, is the right to appropriate treatment. The facility has no right per se to treat. They have an obligation to provide appropriate treatment within the structures of informed consent and privacy. So it's just the phrasing which was challenging for me. With respect to private schools and institutions, a private school is not a psychiatric facility licensed, operated, or contracted by the Department of Mental Health. So it kind of falls outside the scope of this discussion. There are schools and programs for persons with ID or DD that are residential programs, but that's outside the scope of this discussion. And then we have one more if we have time, if you'd like to take it now.
Sure.
My daughter was transferred to a facility. A hearing of incompetence to a state institution was upheld. Does the institution have to adhere to the original hearing?
I would first just note that you can challenge that ruling of incompetence. I think probably at any point, if they're, and then if she were involuntarily committed, you can also challenge that commitment under, I think, is it 9B?
9A and 9B.
9A and 9B. Walter, if you would like
Yeah,
to.
I think again, we're nitpickers because we're lawyers, and the words used are a little troubling. A hearing of incompetence, just right there, is generally when someone is petitioning to place a person under guardianship. A hearing that results in a person being placed in a state institution against their will is a commitment hearing. So they're different things. They're apples and oranges. Does the institution have to adhere to the original hearing? Well, again, for example, if a person was placed under guardianship at a year prior, and then they found themselves in a hospital, if that guardianship was still in a place, sure, there's something in the law called full faith and credit. If you're into guardianship in New York, that should apply in Massachusetts, with very, very limited exceptions. So generally, good law will travel with the individual regardless of where they go. So I think it's the language of a hearing of incompetency. I think what you're talking about is a petition for guardianship. If the individual was placed under guardianship, then they were to go to an institution of any type. The guardian would be able to speak to the institution and the caregivers at the institution with or without the individual's consent, again, depending on the scope of the guardianship. This stuff gets very individualized. And so there isn't a one-size-fits-all answer. And I'm just going to jump ahead and answer the last question. I'm going to do a workshop in this format about restraint and seclusion, and it's going to be a bag up thing, and I hope you participate. So I'm going to turn that back to Ginger.
Thanks, Walter. That will be on July 27th, and we will definitely plug that before we conclude today. I think we can move to the next slide, please. Thanks. So we've kind of talked a little bit about Rogers orders, but that's really the fourth way that you can be treated with antipsychotic medication without your consent. And it's similar to the 8B, but it's not exactly the same. For example, the Rogers order is petitioned for in the probate court rather than the district court. Again, the standard is substituted judgment. So the court first has to find that the person is incompetent or they lack capacity for informed consent. And then the court determines what the person would decide if they were competent based on those factors that we discussed before. If you are the subject of a Rogers order, you are assigned a Rogers monitor who monitors the implementation of the order and reports to the court annually about the progress of the order. And like these, the orders are reviewed on an annual basis. And unlike the 8B, the order does not automatically expire if your commitment to an institution ends. As Walter noted, you have the right to an attorney when you're undergoing a Rogers. And I don't know, Walter, if you had anything you wanted to add specific to the Rogers order.
Yeah, I do. I think when you raise the idea of the Rogers monitor, that's really important. There isn't a monitor on the 8B, and a Rogers monitor could be a family member. And in my experience, there's been some great Rogers monitors. They're not the same as a guardian.
Right.
They're in your corner by and large. Mm-hmm. And if they see that the medication isn't working, or that, a lot of these medications have serious side effects, right? Tardive dyskinesia, diabetes, weight gain, you name it. That's why they call it extraordinary care, because there's real serious risks involved. I think there's an affirmative obligation for the Rogers monitor to step up and to make it clear to the court that there are problems. Now, the Rogers monitor doesn't have the right to say, stop taking your medication, but they do have the obligation to make it clear what they're witnessing. If they witness their son or daughter or husband or wife acting in a really detrimental way, or they're developing other symptoms or gaining a lot of weight or lethargic all the time, yeah, that Rogers monitor is really, really important. It's almost like a guardian ad litem. They inform the court as to whether this plan is working. And it's very important because Rogers orders sometimes go on for years and years and years.
Right.
Even though they're supposed to be reviewed every year, let's face it, sometimes they're just rubber stamped. So the Rogers monitor is a really important role.
Thanks. We can go to the next slide. So that kind of concludes our discussion about informed consent and the right to refuse treatment. But you also have other rights related to treatment, including what we've talked about a little bit, which is the right to treatment suited to your needs. So each patient admitted to a facility shall, subject to his or her giving informed consent, receive treatment suited to his or her needs, which shall be administered skillfully, safely, and humanely with full respect for dignity and personal integrity. So let's break that down a little bit. Your treatment should be suited to your needs, meaning that treatment should take into consideration your pre-existing conditions, for example, any previous treatment successes and failures. And of course, it should take into account your opinion on certain medications and treatments and what you feel is in your best interest. And as the regulations note, that treatment should be given with your informed consent. I just want to highlight some additional thoughts for transgender people, because we did have some questions about that at our last training session. I just want to note that both federal and state law protects LGBTQ+ people from discrimination in health insurance and health care. Under federal law, the Affordable Care Act provides that protection, and under Massachusetts law, it's the Section 151B or Chapter 151B. That law prohibits discrimination against LGBTQ+ people in healthcare settings and other places of public accommodation. I think it's also worth noting that MassHealth, which is the state's Medicaid agency, the Massachusetts Division of Insurance, which is the state agency for private insurers, and the Group Insurance Commission, which is the agency for state employees insurance, have all issued directives requiring coverage of all medically necessary gender-affirming care, which includes hormone therapy. So I think as a trans person, if you are hospitalized while you're undergoing hormone therapy, that therapy should be continued as it is suited to your needs, right? Especially if that treatment is considered medically necessary. So I just wanted to make note of that since we had some questions about that at the previous session. We can go ahead to the next slide. You also have the right to participate in the development of your treatment plan. We've talked a little bit about this. The patient has the right to participate in the development and implementation of his or her treatment plan. That's right in the regulations. The treatment plan should be in written form, and it should include an assessment of your strengths and your needs. And it should be developed with maximum possible participation from the patient or from the patient's legally authorized representative, like the guardian, healthcare proxy, your legal advocate, and even your lawyer. I think collaboration on the treatment plan is really important. I think it on the one hand, it demonstrates to your treatment team that you are engaged in your treatment and you're engaged in the treatment process. And it's also really important for you to have your voice heard concerning the treatment that you want. You know, especially for trans folks, this is your space to raise your concerns about what treatment is going to be suited for your needs. There should be periodic assessments of the treatment plan, and any modifications to the treatment plan and the rationale for those modifications should be documented in your record. And all of the treatment plan, any modifications, all of that should be in your medical record. So I think with that, we'll go to the next slide and we'll talk about your rights with regard to your medical record. So each facility must maintain a patient record containing all the significant clinical information for you as the patient. That includes admission information, your diagnosis, any healthcare proxy information and advance directives, your medical history and results of any psychiatric or physical evaluations, commitment orders or records of transfer. All of that should be included in your medical record. You, as the patient, you have the right, you and your legally authorized representative have the right, you'll be permitted to inspect your record. Like any other law, there's some exceptions to this. If viewing your record is reasonably likely to endanger yours or another's life or physical safety, the facility does not have to allow you to view that record. For example, if reading your diagnosis would make you go into crisis, the facility may deny access to that record. And that decision must be made by a licensed health care professional and not an administrator of the hospital. Another instance where they might refuse to allow you to look at the record is if the record makes reference to someone other than a healthcare provider and inspection is reasonably likely to cause substantial harm to that other person, or if inspection by the legally authorized representative, your guardian or healthcare proxy, is reasonably likely to cause substantial harm to the patient or to another person. If you or your legally authorized representative are denied access to any of your records, you must be informed about that denial, and then there should also be a way for you to appeal that decision as well. And your attorney must be permitted to inspect the record as long as you give your consent. We can move to the next slide. You also have rights regarding amending your medical record. So if you disagree with something in your medical record, you can request an amendment. Under federal law, which is the Health Insurance Portability and Accountability Act, HIPAA, you've probably heard of it, you can't delete information from your medical record, but you can add information. So if you request an amendment to your record and the facility can deny that request for amendment. For example, if they believe the record is complete as is, they can deny to amend the record. But if they refuse to accept that amendment, you can file what's called a statement of disagreement. And that statement of disagreement has to be linked or appended to the record, to your medical record. And anytime you or somebody else requests that medical record, that statement of disagreement also has to be included in disclosure of the medical record. Excuse me. Under Massachusetts law, it's similar. Facilities are holders of personal data, and they must allow individuals to amend the record. And if you and the facility disagree about a change, the facility, again, must ensure that the claim is noted and is part of the record and included in any subsequent disclosure. So essentially, you can make a point that you disagree with what the record says, and that disagreement must be included in future disclosures of the record. You can move to the next slide, please. You also have the right to interpreter services. Each facility shall, in connection with the delivery of inpatient services, if an appropriate bilingual practitioner is not available, provide competent interpreter services to every non-English speaker who is a patient. So they have to provide you with interpreter services if there's no bilingual practitioner available. The facility can provide these interpreters through, employment of interpreters, through contract, or they can have on-call interpreters. They can use telephonic or televiewing interpreter services, but only when there's no reasonable way to anticipate the need for an interpreter, or if they can't, get a contracted or employed interpreter. The idea is that the video or telephone interpreter is really supposed to be kind of a last resort. But of course, as the pandemic has been going on for the past year, we have seen an expansion in the use of video interpreter services. These services have to be available 24/7. And I think it's also worth noting that the facility should not be requesting, suggesting, or encouraging that a patient use a family member or a friend as an interpreter. And that is especially true for young children. So they really should be providing the interpreter services themselves. The facility should be providing those services. And finally, the facility must provide you with information about interpreters and your right to an interpreter in the language that you speak, in your primary language. Move to the next slide, please.
Before we get, excuse me, I don't mean to interrupt, but I should have jumped in earlier. There was a question regarding amending the records, which is what information would need to be provided to request an amendment?
So what I would usually point people to if they are looking to amend the record is to the human rights officer at the facility. Many facilities, they usually have a form that they use to request an amendment of the record. If you have observed and looked at the record, you can probably find exactly where you want to change and amend the record. But essentially, the information that you would need would probably be your name, your date of birth, those kind of basic identifying pieces of information so that they can locate the record that you'd like to amend. Is there anything else that you would add, Walter?
Well, yeah, I think that, I think you need to talk about what you're disagreeing about. If you're amending a record, there's a presumption that you've looked at the record. So you would say something like, in such and such a document would say, the treatment notes on such a date, Dr. So-and-so described that I have a particular diagnosis. You may disagree with that diagnosis, and you may have another doctor who would support you in that. So I think in an institution, that was funny. In an instance like that, you would want to provide as much factual information to show that you're not just saying, no, that's not true, but you're saying, well, that's not true because I have been a person receiving services for the last 15 years. My diagnosis has always been X. And here is this person describing, and not just identifying a diagnosis that may not be true, but that diagnosis that may not be true may result in treatment decisions that may not be appropriate or effective. And also, Ginger has done great work on this, and I don't question any of her comments on the law. But I think amending, you can't strike things from a record, but I think the right to amend the record is really powerful. And if a facility refuses to allow you to amend a record or to insert something in the record, I think that is an appealable issue. I also think that when you do have something added to the record, if you're challenging page 45, you want your amendment to be at page 44 or page 46. You don't want your amendment to be at 137, which shows that doesn't mean anything to anyone. So you want it to be placed in the record where it means something. And this idea that you can simply say, I disagree, but you can't say anything more, because I think, we have federal law under HIPAA and we have mass law, and there's all kinds of rules and criteria for what we do when state law and federal law converge. But that would need a deeper discussion. And if somebody had something that they were not allowed to amend their record, speaking only for myself at Disability Law Center, that would be an issue that I think we would be interested in hearing, because the right to amend a record, particularly when they simply got it wrong, is extremely important. And they can't just say, well, no, we're not going to let you amend it without providing a reason and something that makes sense. So I think that would be an appealable issue. So sorry for jumping in, but I wanted to Thanks.
The final thing that I wanted to bring up was the right to reasonable accommodations under the Americans with Disabilities Act. Under Title II and Title III of the ADA, hospitals and doctors' offices must provide reasonable modifications to policies, practices, or procedures to ensure that people with disabilities are not discriminated against. So Title II applies to state and local government entities. So this would be hospitals run by the Department of Mental Health. Again, they have to provide the reasonable modifications that do not fundamentally alter the nature of the services, programs, or activities that are provided by that facility. You know, an example of this would be providing American Sign Language interpretation for deaf or hard of hearing patients who use ASL. Title III applies to places of public accommodation, which that would mean private hospitals. So, you know, even a totally private hospital like McLean, they still have to provide these reasonable accommodations. So same idea as Title II, they must provide reasonable modifications unless they would fundamentally alter the services provided. So McLean Hospital, they also have to provide ASL services to deaf or hard of hearing folks. They may have to provide, you know, information in Braille for blind people. So both the DMH operated and other private hospitals, they're required to follow the requirements of the ADA. So I think that concludes our presentation. I know we don't have very much time, but if there are some additional questions, we'd certainly be happy to take them. Otherwise, I will just note that our next session is on July 27th. And as Walter said, we will be discussing restraint and seclusion. So a very big topic, very important topic. So I don't know if there were any more.
We have no more written questions that I see.
Okay.
I think we've addressed them all. If I could just state one thing before we go, if that's all right.
Of course, yeah, please.
And I think you've said all of this, but earlier this year, I had a client in a hospital, which will remain nameless. And, you know, this all calls under the heading of believe the client, trust the client. The client knows their disability. They know what works and what doesn't work.
Right.
And then this person kept telling the doctor that she was allergic to a particular medication. Her social worker called the doctor and said she was allergic to the medication. And this went on and on and on, but the doctor nonetheless prescribed the medication. We were able to get involved. We filed a complaint and an appeal. And not only was the doctor reprimanded, but actually the doctor had to be monitored by the director of medicine for that facility because of this sort of idea that I'm the doctor, I don't have to listen to you. I know what's best for you. Mm-hmm. Informed consent basically says, no, you don't. I know what's best for me. Mm-hmm. And that's in all, that's almost in everything, but it's certainly in all areas of medical care. And if you think about it, when we go to the doctor and the doctor is even going to listen to your heart, they ask permission. They say, I'm going to listen to your heart, okay? Or this may hurt a little bit, but that's not what they do in psychiatric facilities. And it's very, very troubling to me. So what's really important is your body is inviolate. Nobody has the right to touch you, examine you, treat you, or do anything to you without your permission. Mm-hmm. And that's why I say it's grounded in tort law, because it's a form of unlawful touching. Right. To give you medicine that you don't want, that you don't think you need, and they don't have any right to give you is like, well, it's not like punching you in the mouth, but it is insofar as that they are inflicting a harm upon you without your permission. So I just wanted to share that little bit, but great job, Ginger, and I hope you folks enjoyed it.
Thank you, everyone. I hope you'll join us on the 27th, and I think that will do it. Thanks, everyone. Bye-bye.
Bye-bye.